These types of debates are really the core of FedSoc's mission, so I'm glad that you could come out and be a part of it. So our moderator today will be Professor Jeremy Rabkin, who is a law professor here. Many of you have had him before, and he really does need no introduction. So I'll turn it over to Professor Rabkin.
Okay, so the panelists hardly need any introduction either. Professor Somin has been teaching here since 2003. Josh Blackman was a student here.
Of Ilya's. And Rabkin.
And he's going forth and done great things in the world. He has several books and the common law text, right?
Yeah.
And it's worth mentioning Professor Somin has had an amicus brief with a number of other people in some of the cases on the current travel ban. Professor Blackman had amicus briefs on the DAPA litigation, so they're both actively engaged in arguments about current litigation. The way we're going to do this, there's some background which would be useful for all of us to have. So we'll have Josh Blackman speak for about 20 minutes, both to lay out the background and to give his side of the argument, and then hopefully Professor Somin can reply a little bit more briefly. We'll have a few minutes for each of them to engage in rebuttals if they want to, and then if I'm not moved to ask a question, which I may not be, throw it open to you. So,
thank you.
go speak.
It's a pleasure to be back at George Mason. I graduated here in 2009. I started in 2006. Like many of you, I had no idea what the hell I was doing. So there is light on the other end of the tunnel. And especially...
And the room has not been painted.
The room has not been painted. It looks exactly the same. It's actually startling. But that thing in the middle used to be a parking lot. That building in the middle did not exist when I first got here. And Ilya was my property professor. I had him for, I think, I got an A+ in your class, and I did quite well. And I've been grateful to have his companionship. I got an A or an A+, so I'm in good company. Our topic today is the travel ban. And the timing of this event was to coincide with the oral arguments at the Supreme Court in the case of Iraq versus Trump. As we know, that did not happen. The Supreme Court took the case off the calendar. But these issues are not going away. Even if the current litigation is dismissed as moot, which I'm sure Ilya and I will talk about, this issue will come back up in the lower courts and probably at the Supreme Court later this year. So before I begin, I'd like to compare my views in this case to another person who is very near and dear to the school, which is Justice Scalia. And you may know that Justice Scalia cast deciding vote in a case called Texas versus Johnson. This was a flag burning case. And this was one of those cases that Justice Scalia would always hold up as where his personal views conflict with his views in the Constitution. And Scalia once said, this is a verbatim quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But I am not king." Now, we know what Scalia would say about this. We know what he would say about maybe taking a knee. But Scalia cast the tie-breaking vote in the Johnson case to give the right to the flag burner. And that's how I feel about the travel policy, the travel ban. I'm a libertarian. I generally favor open immigration policies. I think the idea of banning aliens from other nations simply because those nations are associated with terrorism is a terrible idea, awful policy. These executive orders will cause hardship to families, refugees, and others seeking a better life. I'm also doubtful how much this will do to protect our security. Yet my cards are on the table. I am firmly convinced that Congress gave the president the power to take these actions, and the Constitution does not bar him from exercising the power in the manner in which he did. So in my brief time, I will try to accomplish 5 things. First, I want to walk through the history of the travel ban, which I think actually most of the time, including statements by then candidate Trump and by now President Trump about the policy. Second, I will discuss the contents of these 3 orders, which have been halted by the courts in one form or another, at least 2 of them have. Third, I want to discuss whether Congress gave the president the power to take these actions. This is a separation of powers analysis. Fourth, I want to discuss the Establishment Clause. And finally, if we get time to it, what's coming next after the Supreme Court vacated or took the case off the calendar. So we really have to begin our study of this issue back in December of 2015, when the idea of President Trump was but a glimmer in our eyes, right? Actually, I'll give Ilya credit. We had lunch a couple years ago and said, you know, Josh, I think Donald Trump will be president and Marine Le Pen will win in France. So you were half right.
People say Marine Le Pen would win.
You said she could win. She could.
Not the same thing as win.
See, we're debating. I'm trying to give her a kind of compliment. But anyway, you definitely said Trump could win, and I thought you were insane, Ilya, and Ilya was right. So back in December 2015, Donald Trump called for, here's a report, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. That's, I read you the verbatim quote. Over the next few months, Trump announced a different position. He said he would impose extreme vetting on people from certain territories. He doesn't like the word countries, he likes territories. I don't know why. From certain territories. Did he actually repudiate his position? Well, he told Leslie Stahl, call it whatever you want, but we'll call it territories. Was this a repudiation or a wink of the nod to the alt-right? He also said on Meet the Press, I'm talking territory instead of Muslim. Now, that's not a complete sentence, but at least he's saying he's not sticking to the Muslim ban. Did he mean it? Did he don't? I don't know. Fact checkers have gone insane trying to figure out what Trump says. In the same sentence, he can often contradict himself, which I think is good policy of why courts should perhaps back off even trying to parse these sorts of statements. We fast forward now to January 27th of this year. This was 1 week after, one week after the inauguration. President Trump issued what I'll call the first executive order of immigration. It sent shockwaves throughout our legal order. For 90 days, aliens from Iraq, Iran, Libya, Somalia, Syria, and Yemen were deemed detrimental to American interests, and we denied entry. And then for 120 days, the refugee admission program would be suspended. Syrian refugees, in particular, would be denied indefinitely. This unleashed chaos. Almost immediately after the order was signed, airport officials began to detain people from these nations. And these cases, what I've called the airport cases, judges in New York, Virginia, Washington, and Massachusetts prompted their release, right? They ordered them to be released. But those proceedings were only the beginning of this lawfare. Soon enough, the Ninth Circuit affirmed that the injunction. The government decided not to appeal to the Supreme Court. They said, we'll try again. Fast forward to March 6th of 2017. The president issued a new executive order that superseded the first one. It removed Iraq from the list of countries and made clear that lawful permanent residents, that is green card holders, were not subject to the ban. And also it shifted the justification. Rather than quantifying whether aliens engaged in these terrorist attacks, they said, we find that these countries lack sufficient diplomatic relationships with the United States to trust them and their screening mechanisms. This policy, too, was challenged in court, and it was enjoined by district courts in Hawaii and in Maryland. These cases were appealed up to the Fourth Circuit and Ninth Circuit, respectively. The en banc Fourth Circuit decided that this policy violates the Establishment Clause, which we'll get to a little bit later. The Ninth Circuit had a slightly different rationale. They said the president did not make the requisite findings under the statute to deny entry to these classes of aliens. It was too speculative. Okay? Over the summer of 2017, this went back up and down to the Supreme Court 3 times about who could be denied entry, right? Could grandma be denied entry? Could grandpa be denied entry? Could, aunts, uncles, nieces, nephews, right? How close of a relative would be allowed in while these litigation was pending? In 3 times, 3 instances, the Ninth Circuit ruled against Trump, and then on 3 occasions, the Supreme Court kind of did this middle-of-the-road thing where they gave something to the plaintiffs and something to the government. They said, leave us alone. We all knew what was coming, though. The travel ban, the second iteration, was not a permanent policy. It had an expiration date of 90 days. And that policy would wind down in the end of September. And virtually everyone in Ilya would agree that we knew something was coming at the end of September, and we got it. So on September 24th, about 2 weeks ago, President Trump issued a third order. This was a proclamation. What's different between an order and a proclamation? Not much. The Department of Homeland Security created a baseline for each nation to meet, and then measured whether a country met that baseline. 16 countries were found to be deficient, 31 others were at risk. According to the report, the Secretary of State engaged with these countries to show improvements. Ultimately, a small number of countries, 7, were claimed to be deficient despite the government's engagement. So the 7 countries are Chad, Iran, Libya, North Korea, Syria, Venezuela, and Yemen. So what changed? Sudan, off the list, mazel tov, right? Your Sudanese grandmother can come here, no problem. Added to the list, though, were Chad, North Korea, and Venezuela. Now, as you might imagine, there are not many North Koreans visiting the United States. So this is basically a non sequitur. It doesn't really change anything. Venezuela was not added the entire country, just certain diplomatic officials. So again, it's a fairly small number of people we're talking about. The only significant new country is Chad, which this is a majority Muslim nation. So we're basically still stuck with majority Muslim nations on the list. Okay, so after the government announced its new policy, the Supreme Court ordered a round of briefing, and they took the case off the calendar, which is why this morning there was no humongous case argued. At this point, the government is saying that these appeals are moot. Let's go back down to the district court, vacate the lower court opinions, and start from scratch. The plaintiffs argue, no, it's not moot. The government hasn't really stopped their unlawful conduct, and that this third order is still tainted by the original sin of the first order. Which is why, even though the court took this case off the docket, I think it's still relevant to debate this, which is why Ilya and I are, I think, still doing this today. So I want to turn next to statutes, right? We learn in common law, and I hope you take Professor Somin and Professor Rabkin for common law, that when the president acts, there are two possible sources of authority, a statute or the Constitution, right? It sounds formalistic, but basically that's where authority comes from. I'm going to table the question whether the president has the inherent Article 2 power to deny entry to people. I think there's some merit there, but I don't need it. I don't need to go there. I do think it's in the background. But I will focus instead on the statutory framework. So we have a statute, 8 U.S.C. 1182F. It provides, I'll read it to you. Whenever the president finds that the entry of aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation, that's a proclamation, right? He may by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens, blah, 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 blah. So, in terms of statutes, that's a pretty direct delegation of authority to the president, right? If you take admin law, you have a statute, the government shall regulate air so it shall be clean, right? Well, what the hell does that mean? I don't know. Courts generally say it means whatever the executive wants to mean, Chevron deference, we defer. This is a pretty explicit delegation of authority. If the president deems someone would be detrimental, they can be denied entry. This has been used by many presidents over the years. For example, President Reagan denied entry to all Cubans, the entire nation, after a tiff with Castro in the 80s, right? So I think in terms of, if we look at Youngstown, we have a very good indication that Congress gave the president the power to deny entry to a class of aliens he deems would be detrimental. I don't think this requires specific findings of fact. It never has in the past. The presidents have denied entry without any specific findings, short of a simple proclamation. Now, there's another statute passed as part of the 1967 Immigration Nationality Act. And this was a statute that, I'm going to summarize, it says, with respect to the issuance of visas, you cannot discriminate on the basis of nationality among other classes. Not religion. Actually, religion is not mentioned there, which I think is significant. Now, Ilya and others have argued that this statute came later in time, and because you have a later in time statute, it trumps the earlier in time. Well, I think you only get there if there's actually a conflict. And there are two concepts here. One concept is entry, and one concept is visas. You can have a valid visa and be denied entry. For example, if you show up at the airport, you show up at Dulles, you have Ebola, guess what? You're not coming in. They're going to turn you right around. You come to the checkpoint with a valid visa. You answer some questions. The agent figures out you're lying and you committed fraud. Guess what? You're not coming in. Even though you're on U.S. soil, until you cross the checkpoint, you're not in the United States. So denying entry is totally separate from the issuance of visas. Okay? So I think these are separate concepts that are relevant here. But even if they're not, right? Even if I'm wrong, I think here Article 2 comes into play. I think we should read the statute to avoid restricting the president's power to deny entry. I think it's a constitutional avoidance point that's worth mentioning. And presidents have used this in the past, and there's never been any allegation that they're violating the statute. So I think in terms of the statute, the president has the power. It doesn't run afoul of this non-discrimination provision. And just as an aside, if you actually read the statute, there's another paragraph, subparagraph B, which basically says the secretary can make rules notwithstanding paragraph A. So I think they can probably do this under the subparagraph B, notwithstanding the first paragraph, but I don't want to get too far into the weeds. The other argument, the one more sexy argument that you came here to talk about, is the Establishment Clause. Usually when we talk about the Establishment Clause, we think about, prayer in school, right? Or a Ten Commandments monument in a courthouse, right? Or something like that. This is a slightly different type of Establishment Clause case. The argument here isn't that the president's trying to establish Christianity as a religion. What they're arguing is that he's showing disfavor of Islam, right? That by supporting one religion, he's showing a disfavor of another. It's some of a weird fit between the Establishment Clause. I actually think this is a due process case. I've always thought this. We're saying the president lacks any rational basis to act because he's motivated by animus. It's like a Romer type analysis, right? The president's so motivated by animus of Muslims and Islamophobia, he lacks a rational basis. I think that's actually the correct framework, but they can't bring due process. Why? Because aliens outside the U.S. have no due process rights to enter. So they have to shoehorn it into the Establishment Clause, which was never a good fit. And they say the Establishment Clause is structural. But let's take the argument for what it is, right? Is the president running afoul of 5 minutes? Right on time. Is the president running afoul of the Establishment Clause? The key pieces of evidence are the president's own statements. He undermines his lawyers at every conceivable junction. It's awful, right? Imagine having a client like President Trump. I would not want to. It'd be very difficult to have that. So what are the arguments? You know, it said we want a complete shutdown of Muslims, all the other things before the campaign. There is zero precedent to the effect that the president courts can cite statements in the campaign trail. There's no precedent for that whatsoever. I think there's very good reason not to. When the president takes an oath of office, that has significance. I've described it as a constitutional baptism. It cleanses you, so to speak, right? You undergo this new process. Now, maybe with Trump it didn't, but as far as the courts are concerned, I think there's very good prudential reasons not to look to campaign trail statements. A good Establishment Clause charge, it's baptism, right? But after the campaign, I actually think the president's statements could be fair game. In fact, Professor Rabkin and I, we wrote a brief with him last year on the immigration case, saying that we can look to President Obama's statements. I think that's fair game. But here, we have some case law that limits that. There was a case from the 1970s called Kleindens versus Mandel. The facts of the case were that you had a Marxist professor from Belgium, and he wanted to visit the United States to give a speech. He applied for a visa. Visa was denied. Now, they gave some bogus reason why the visa was denied, because he had overstayed a past visa or some trivial thing. What was the real reason the visa was denied? Richard Nixon didn't like Marxists. That was the reason the visa was denied. It was appealed to the Supreme Court in a very strange opinion. I don't think anyone had standing, but we'll put that aside for the minute. It was appealed to the Supreme Court. By a vote to 8-1, the court ruled against the Marxists. They said, look, we're not going to look behind the president's decisions. They said, we will look to see whether the order is facially legitimate and bona fide. Right? Now, the way I read that is facially modifies both words, legitimate and bona fide. If you have a facial legitimacy, but then you have a below-the-surface bona fides, why bother saying facial, right? If you can always look behind the surface, why bother putting the word facial in there? It basically reads facial out. So if you looked at the face of the denial, a real reason was given. And that's our rule. That's our decision. We have a rational basis review. That's it. If the government gives a facially legitimate reason to deny entry, they can be denied entry. That's the beginning and end of the story. So the president's statements simply are not relevant. Now the lower court says, well, there's evidence of animus and everything else. The Supreme Court hasn't gone there. And if Justice Kennedy wants to make up his mind and say that we can look behind the decision for immigration actions, then we can. But that's not the law now. Now, in my remaining minute and a half, I want to talk about what happens next. The big question for the Supreme Court is this. If the case is moot, what happens to the precedents from the 4th and the 9th Circuits, right? What happens to those precedents? There's a doctrine called Munsingware, which sounds like a pair of lingerie, right? The Munsingware doctrine, right? Which basically says if the case becomes moot while it's being appealed, you vacate the lower decision, as you wipe it off the books. But there's some exceptions to Munsingware, where if the party's own conduct renders the decision moot, you don't vacate. This doctrine is not hard and fast. It's not a strict rule. Now, why does it matter? Because if you wipe the decisions off the books from the 4th and 9th Circuits, it becomes a little bit harder for the plaintiffs to win on remand, because they're starting from the blank slate. Now, I don't think it'll matter. If you had a judge rule against Trump once, rule against him again. So I think it makes no difference. But what this does have the effect of doing is wiping these books off the precedent so they can't be cited in the future. I tend to think the court will vacate the lower court decisions, probably take the case off the calendar. They'll go back down to lower courts and rock it back up in about a month or so. And so I think we'll be back to the Supreme Court maybe March, and maybe Ilya and I can do this debate all over again later this year. Jeremy, I'm good on time?
Perfect.
Thank you all so much. And I'll turn over to my dear colleague, Ilya Somin.
So
Thank you all for coming and for organizing this. It's an honor to be here with Jeremy and with Josh, who is not only one of the most distinguished graduates of this law school, but probably one of the best young law professors anywhere. I certainly recommend to you his books on the Obamacare cases and their aftermath, which are probably the most thorough accounts of that particular subject. But all of us have our flaws and Achilles heels, and Josh has too. One of them is that he continues to be a Yankees fan despite all the awful things that the Yankees have done. The other one, which we will talk about today, is that he tends to be wrong about constitutional issues related to immigration. It is probably the case, as Mr. Miyagi said, that there are no bad students, only bad teachers. So I, as one of his teachers, am responsible, and I'm going to do what I can today to correct my error. So the travel ban case at its heart is about two simple and important issues. One is that the overwhelming evidence shows that this case was taken for the purpose of targeting and discriminating against Muslims to carry out the president's campaign promises to that effect. Secondly, the key issue is given that whether the Bill of Rights applies to government actions in this area the same way as it applies anywhere else, or whether there's some kind of special exceptions for immigration or for entry into the United States. And my answer to that question is there is no such exception. It's not in the text of the Constitution. It's not required by Supreme Court precedent. To the extent that some precedents can be read to require it, they should be limited or overruled. So let's talk about the evidence first. Josh frankly mentioned only a small bit of it. Not only did Trump call for a Muslim ban on numerous occasions beginning in December 2015, but when he shifted to the so-called territorial policy on a dozen separate occasions, he equated that policy with the policy of excluding Muslims. He specifically said in one instance, for example, that this was actually an expansion of the previous policy. Moreover, his advisor, Rudy Giuliani, one of the people who helped craft this policy, said in an interview after the election, by the way, after Trump was took the oath of office, that he said that Trump had instructed them, we have a Muslim ban, now make it legal. So when you look at all of Trump's statements like this, you have a classic case of what lawyers call pretextual discrimination, using a category which is not in and of itself prohibited to engage in a form of discrimination that is to target people on the basis of race, sex, nationality, or in this case, religion. The interesting thing about this case is that it's actually an easier case than most other cases that fall into this category because, first, there's only one decision maker, the president, so only his motives are the ones that are ultimately crucial here, and that makes it much easier to analyze than many cases which involve the motivations of multi-member legislatures or boards or committees or whatnot. Secondly, as Josh said, this guy is a pretty bad client because he has repeatedly said what his motives are. There isn't any particular mystery. He's said it time and again many times. Now, some people say, well, there's a baptism, as Josh calls it. When he becomes president, you ignore everything he said before. I'm not a religious person, so perhaps I'm missing some conversion experience here, but frankly, it looks like a bunch of hooey to me. Frankly, what's really going on is that he's the same man now that he was during the campaign. He behaves the same way. He pursues the same agenda. The evidence is pretty clear on this. I think common sense points in this direction. So does decades of political science and social science evidence of other kinds. Studies repeatedly show that presidents and other politicians try very hard to carry out their major campaign promises. In fact, presidents usually carry out or try to some 70% or more of them, and that's higher for major ones that they repeated many times that were of special importance to their base. The Supreme Court, in dealing with pretextual discrimination cases, they have said that, quote, the historical background of the decision is relevant, and, quote, the specific sequence of events leading up to the challenge decision. That's from the Arlington Heights, the leading Supreme Court precedent on pretextual discrimination. Frankly, I think it's pretty darned obvious that the president's campaign statements are part of the specific sequence of events leading up to this decision. Indeed, absent that sequence, it would never have happened in the first place. I think that's pretty darned obvious as well. Now, the Supreme Court has said that even if there is evidence of unconstitutional pretextual motives, such as in this case, discrimination on the basis of religion, the government can rebut that by showing they would have done the same thing anyway. In this case, if they could rebut it at all, by showing, well, there's a real security rationale for this that would have led us to do this, even in the absence, even if, for instance, Ted Cruz had been elected president, or Hillary Clinton, or whoever else, the same thing or something similar would have been done because, you know, there's a good security case for doing this. Sadly for the president, there just isn't. The total number of Americans or people of any kind killed on American soil by refugees or immigrants or entrants from any of the countries covered by any of the iteration of the travel ban is zero in the last 40 years. Somalia, that nobody killed, only named. And I'll get to that, but it's killed. But still, it's striking that in decades, nobody has been killed by an act of terrorism from an entry from one of these countries. There have been a very small number of instances of terrorist attacks that didn't lead to death. That instance is actually lower than the incidence of terrorism by native-born Americans. So we're talking about a risk that is vastly, vastly lower on a per-person basis than the chance an American will be killed by a lightning strike. In fact, in a given year, you're more likely to be killed by a lightning strike than to be killed in an act of terrorism by any immigrant from any country anywhere in the world. Moreover, it's not just that this travel ban fails to protect national security, it actually makes things worse. For example, in several of these countries, we have ongoing operations in the war on terror. In Syria, for instance, we often need the cooperation of locals to help us identify terrorists, go after them, and the like. The third iteration of the travel ban, the summit, and also the second, has a presumption against letting in any people from there. They do say, well, lower level officials at their discretion might be able to let some people in. Frankly, if I was a Syrian who risked my life by cooperating with US forces, I would not bet my life on the discretion of lower level bureaucrats, especially not an administration that's as biased against immigration from Muslim countries as this one. So in that respect also, this actually damages national security. Furthermore, Trump is not the only person who has praised this travel ban. The leaders of ISIS have also praised it. They call it a blessed travel ban. Why? Because it damages the image of the US in the Muslim world. It makes it harder for people to flee places like Syria where ISIS has some control. And obviously ISIS would rather have more people under their control than fewer. So not only is this order not actually promoting national security, it's actually damaging it, it's helping the enemy. Now, in and of itself, the fact that it's bad policy might not be legally significant. The fact that it's evil and immoral may not even be legally significant. But when you combine that with the illicit motivations and the statements thereof, it's pretty obvious that the government has no adequate or even remotely plausible rebuttal to the illicit motivation point. And therefore, this evidence of the illicit motivation, it's overwhelmingly likely that's the true motivation, and that's true for the first travel ban and for the second one. And it's also true for the third that I will now talk about. As Josh mentioned, there are a few differences, but fundamentally, the order is very similar. One big difference is that there's now a permanent travel ban. So they no longer have the excuse of saying, well, we're just going to come up with procedures for extreme vetting. For the 6 Muslim majority countries on the list, no amount of extreme vetting, it turns out, is sufficient to admit people for immigration visas from any of them, and for most categories of non-immigrant visas, that will be true as well. They did drop Sudan and add Chad. Frankly, the justification for having Chad on the list is even weaker than for having some of the other countries, because Chad is a strong ally of the US and also of France and the like. But I can talk more about Chad specifically for those who are interested. I don't think this changes much. There is the addition of North Korea and Venezuela to the list. Frankly, as Josh I think also agrees, this doesn't change much either. There are almost no entrants to the US from North Korea other than diplomatic visas, and diplomatic visas are exempted. It's also the case that there has never been any harm from North Korean entrants to the US, except perhaps the government officials who are exempted from diplomatic visas. Well, he actually could only come under a diplomatic visa.
A missile.
With Venezuela, this only applies to a few high-ranking government officials and their families. So again, I think it's pretty obvious that the addition of North Korea and Venezuela is A, not substantively important, B was almost certainly added for the purpose of creating a smokescreen rather than because there was any genuine national security rationale for it. Now, as Josh mentioned, they do have a new national security rationale which they put forward saying, well, the problem is these are nations that don't, in their view, properly share information with the United States about their entrance. I don't think this is going to carry a lot of weight either, for two reasons. One, as I've already mentioned, there has been virtually zero negative effect in terms of terrorism or violence or security threats from entrance from any of the now 8 countries. So even if there isn't this information sharing, it does not clear that there's any value to having more information sharing. If this risk approaches zero anyway, it's almost impossible to drive it even closer to zero, especially by an order, as I mentioned before, actually increases security risks in various ways. Moreover, when you look at the nitty-gritty of the information sharing and how it works, it turns out that it's not possible to cleanly separate the countries that are banned from the ones that are not, in that however you manipulate the criteria that they've set up, it turns out that there's lots of countries that failed them, that are not on the list, and some of the countries that are on the list can pass them. If you're interested in this, David Beer yesterday did a very good post on the Cato Institute website about this subject. I don't have time to go into details right now, but I don't think this information sharing rationale is going to work. In my last few minutes, I'd like to talk about the idea that, well, maybe this is exempted from normal constitutional standards because it deals with immigration. My first point on this is that there is no such exemption in the text of the Constitution. The relevant part of the Constitution here is the First Amendment. I think it better fits under the Free Exercise of Religion Clause rather than the Establishment Clause, but the Establishment Clause works under modern jurisprudence because the Establishment Clause has been interpreted to forbid discrimination on the basis of religion rather than only forbidding the establishment of official religion. I personally think this would fit better under the Free Exercise Clause, but it's better to have it under the Establishment Clause than to just give the government a blank check in this area. Now, the first thing to notice about the First Amendment is it says, Congress shall make no law respecting an establishment of religion or the free exercise thereof. It doesn't say except an immigration law or except when the law addresses aliens outside the United States or whatnot. There's no exception there in the text, nor was there any exception understood at the time of the founding. Indeed, as has been shown in some excellent recent scholarship by Professor Nathan Chaplin of the University of Georgia, in the 1790s, it was taken for granted by most people that the Bill of Rights would apply to U.S. government actions directed at aliens abroad in exactly the same way as directed at people within the U.S. For instance, as he showed during that period, when we captured suspected pirates on the high seas, it was understood that they had to be tried under the procedures set out by the Fifth Amendment with due process and the like, irrespective of whether they were Americans or French or Spanish or whatnot. And obviously what's true for suspected pirates, the most blatant violators of morality and international law, is also true of peaceful migrants and potential entrants. It is true that since the 19th century, people have thought that there's emerged something called the Plenary Power Doctrine, which says the immigration power is an exception to these normal constitutional constraints. I think this violates the text's original meaning. Moreover, if you look at the precedents in this area, they're actually not all that they're cracked up to be. Many of them either actually apply the same standards that were applied in domestic cases to exclusion abroad. For instance, at times it was permitted to exclude communists, but during that period, when those precedents were set, it was also permitted to put American citizens in prison for being communists. Even in the Mandel case, which Josh mentioned, which is much cited in this litigation, that was actually a case where the plaintiffs did not challenge the notion that you could exclude somebody for being a communist. They just complained about the failure of the Attorney General to grant a waiver, so that case didn't actually address the issue of whether the Bill of Rights applies domestically. But to the extent that you want to apply the Mandel framework, to make a long story short, I would say bona fide that doesn't mean just facially valid. Bona fide is a requirement in addition to being facially valid, and bona fide means acting in good faith, and there pretty obviously isn't good faith in this particular case. Finally, if I have a little bit of time left, I'll briefly talk about the statutory issue. I think of less significance in the long run than the constitutional issue. But to my mind, Josh has set up the issue relatively well, except for the conclusion, which is that I think it doesn't make sense to say that visa and entry are two separate things. The whole point of having a visa is that you have at least a presumptive right of entry. To say that a visa is just a piece of paper that the president can revoke at will, I think that makes a hash of the whole concept of a visa. And here, whatever deference might be granted to the president in a closed case, here I don't think it is close, because the whole point of a visa is to grant entry, and you can't deny visas on the basis of categorical judgments of nationality. I would also make broader arguments here that if this previous statute really does give the president nearly unfettered power to exclude anybody he wants, that strikes me as an unconstitutionally broad delegation, and it has other constitutional problems as well. So if we really want to avoid constitutional problems, we should avoid that one. More can be said, but the bottom line is this. This is discrimination on the basis of religion. It's pretty blatantly so, and it should be struck down. I don't know whether the court will dismiss the current litigation as moot or not. I think either possibility could occur. Maybe it'll still take it up, maybe they'll dismiss it. But Josh is right that if they do dismiss it, we will be back in court on this soon enough.
Thank you.
Thank you.
So, you want to?
Nah, let's go to Q&A. Maybe I'll work my rebuttal into the Q&A, but I'll skip it. I'll waive it.
All right, I'll waive mine as well then.
Let me just ask one question just for clarification. In your view, the president does have the authority to announce certain exclusions from entry to the United States. Could you just give us an example of what you would
Inherent authority or statutory authority?
Statutory.
I think that under that section 1182F, he could announce exclusions that are based on categories not forbidden by either the Constitution or by later statutes. One of those that is forbidden by the later statute is exclusion based on nationality. And
so is Reagan's denial of entry to the Cubans illegal?
My answer, as I understand it, Reagan did not categorically deny entry to all Cubans. He continued the policy of accepting Cuban refugees. If, however, he did deny entry to all Cubans, yeah, absolutely, that was illegal. The fact that something illegal was done at some point in the past doesn't make it okay. Law is not like virginity. The fact that you lose it once doesn't mean it's gone
We're
forever.
talking about baptisms now. We have immaculate conceptions. Come on.
Yeah. So, as a skeptic, I would say that it takes a real change of heart to change your mind, not just dunking you in some water. And similarly, I won't say much about the Immaculate Conception. I would merely say that while a being with unlimited divine power can do such a thing, I don't believe that Trump can.
All right.
Thank you. That's great. No, that was good. So, it's
Fire away. By the way, I took Barbary this round. These awful flashbacks right now. We're going back to that right now.
They covered the Immaculate Conception in Barbary.
Yeah, something like that.
So are we going to questions from the audience, or does Jeremy have additional questions?
no.
So, question for Sue.
We are open to your questions.
All right, Ilya may have answered it, but my question was for Josh. You said you thought it's better that it's more of a due process question than a
Well, free exercise, I actually agree with Ilya. This could be a free exercise case as well, but again, the problem is, do aliens outside the U.S. have free exercise rights? And I think the answer is probably not under current law, which is why the Establishment Clause works. It's structural. It's the present here establishing. That's why they framed it this way. But I think Ilya is also right. I think this could be a free exercise case as well.
I would mention free exercise is also structural in that the First Amendment does not say a certain class of people have a right to engage in free exercise or people in a certain location. It just says Congress shall make no law respecting free exercise, and that by extension, prohibiting. I'm sorry, and that by extension, and that by extension would also constrain the president, because I don't think the president has authority in this area other than what Congress.
Finish your question. Sorry, we cut you
No,
off.
I'm sorry, I didn't realize what you said.
No, that was my question is, so if the due process would not apply, why would the...
It wouldn't.
then why
Under
would-
current law. I think Ilya makes a lot of good points in their first principles, and he's written a very good article, if you want to read it, on whether Congress even has a power over immigration. And I encourage you to read it. I'm trying to, I think, get this ongoing debate with Ilya, limit my arguments to current settled law. Under our law here, there's, I think, very good arguments the Establishment Clause does not apply abroad. And there are a number of statutes and regulations that Congress has enacted which affect aliens, which would be unconstitutional. So I'll give you a good one. If you are a minister abroad and you want to apply for a visa, there's a special category of visa you can apply for as a minister. The regulations implementing that statute say examples of qualified ministers are sisters, monks, brothers, nuns, right? It's obviously talking about Catholics, right? That's what they're talking about. If you have that statute in the domestic context, it will be struck down in 5 seconds. There's another statute, right, which Ilya and I have talked about at some length, which involves a preference for certain people in the Soviet Union. Now, they mentioned Jews, which Ilya will respond in a minute, but it also says Christian evangelicals. Christian evangelicals get special treatment for refugee law. That's an explicit entanglement with religion. There's a lot of good reasons why our immigration law does not have the Establishment Clause attached to it. Even the Immigration Act of '67, which prohibits nationality-based discrimination, 65, which prohibits nationality-based discrimination, does not prohibit religion discrimination, just as mention it. Why? Because we have a lot of religion in our law.
Yeah, so I would respond to this in a couple ways. My more general response is, once again, the fact that the government has done things that are unconstitutional doesn't make them constitutional. You can point to almost any other area of law and say, well, there's long-standing practices in almost every area of doing things that were not constitutional. You can say, well, the cruel and unusual punishment clause doesn't really mean anything because we have a long history of torture and abuse of prisoners, right? But also, even these examples taken under face, I don't think amount to very much. On the ministers, as I understand it, this is not an exclusive list of ministers. This is just an exemplary list. On the Soviet Jews, actually have some special personal expertise because I am one of these Soviet Jews that was let in under the policy as a predecessor to the law that Josh means, and I am an atheist. More to the point, so are my parents, so who were the ones who actually were at issue. The reason why is because Soviet Jews, as understood at the time, were not a category defined by their religion. They were a category defined by essentially whether your passport, your eternal passport from the Soviet government was stamped Jewish or not. And with evangelicals and these other groups, I believe the statute said something like groups subject to persecution by the Soviet government, of which evangelicals were just one of a number of examples. And so,
Jews and evangelicals.
But the list was not. This again was a list of that was exemplary rather than exclusive. And so the operative category was being subject to religious or other kinds of persecution by the Soviet government, rather than actually believing in a particular religion, as indicated by the fact that you could be a Soviet Jew and yet be an atheist. Indeed, the case of my parents is actually not that unusual. A large percentage of the people let in under this provision were not actually believers in the Jewish faith, and indeed no U.S. officials did not make any effort to test to see whether you were a believer in the Jewish faith, so long as you had the necessary stamp in your Soviet government-issued passport. That said, I don't deny that there are some provisions which violate this. I just deny that that makes it constitutional, because again, you can destroy all limits on, virtually all constitutional limits on government power this way. I would note, and I lay this out in much greater detail in my amicus brief that Jeremy mentioned, that when you look at the precedent in this area, a lot of it is not what it's cracked up to be, and that a lot of it simply applies what were the domestic con law standards at the time, like in the case of the communists. And in some other cases, like in the case of Kleindienst versus Mandel, the plaintiffs simply did not actually conceded that you could exclude people based on being a communist. They just said, well, it was unconstitutional for Mr. Mandel to not be granted a waiver from this policy of generally excluding communists. And I think this was a badly reasoned and badly litigated case on many levels. But I personally would be happy to just overrule it, but you can strike down the travel ban without overruling it.
Other questions?
So I don't think anyone is seriously suggesting that we can only deal with terrorism when it's within our borders. So it seems to me that most people could agree that keeping terrorists outside of the United States is a good thing. And insofar as terrorism as we've seen it today shares certain fundamental characteristics, could either of you formulate a travel ban to keep terrorists out of the U.S. that would be desirable and legally permissible?
So,
without violence.
Yeah, let's Ilya go first. That's
okay,
fine.
so you can go or I can go, it's up to you. So my view is that it would certainly be legally permissible to target people based on their actual involvement in terrorist groups or terrorist actions and the like. It might be legally permissible to do it in a wide range of other characteristics that weren't based on religion, ethnicity, race, and other constitutionally prohibited categories, though legally permissible is not the same thing as actually desirable. On the area of desirability, I actually think travel bans are a very poor way to deal with terrorists. If we do identify actual terrorist members of terrorist groups and the like, I wouldn't, even then, the best way is to actually go after them and kill them, or if we know who the people are, let them in and arrest them, rather than, so it seems to me travel bans are actually a very poor anti-terrorist policy, and had the Trump travel ban in any of its three iterations been in place over the last 40 years, it would not have saved a single life, and it would likely have cost a good many innocent lives by excluding the kinds of people that we want to let in because of their cooperation in the war on terror and the like. So ultimately, there are some types of travel ban-like policies that would be likely to be legal, but in general, in terms of what's actually effective, my guess is that we probably want to look at other kinds of measures.
My response is straightforward. That people can disagree about it means courts should not strike it down. That reasonable minds can disagree over what effective counterterrorism policy is exactly why rational basis review is appropriate here. I think it's what Mandela teaches. I think it's what the court's separation of powers jurisprudence teaches, and what the general executive power jurisprudence teaches. We don't know everything the government knows. There are portions of the President's proclamation that refer to classified information. I don't have it, you don't have it. It's not for me to say what the correct national security policy is affecting non-citizens. The scrutiny for such actions are much lower, and I would limit it to only a rational basis review. If on its face a legitimate reason is given, and if on its face it seems the government's acting in good faith, that's it. That's the end of the inquiry. I oppose this policy. I think it's silly. I agree with Ilya. I agree with David Beer's analysis. I think it's spot on. But that's not what a rational basis review requires. Now, if we start applying something higher than rational basis review to national security policy, and Professor Rabkin talked about this, we go down a very dark hole. How many dumb wars have we fought? How many dumb missile strikes have we had over the years, right? If you find some schmuck withstanding, we now can stop, William Douglas stopped the bombing.
And how much due process do we give to the people who we launched those missiles against?
This is a very deep rabbit hole. Very deep.
Yeah. So notice that the same kind of argument can be used in any area of public policy which is at all complicated and subject to this.
Foreign policy, not domestic, and only citizens.
So lots of domestic stuff is also complicated, and also there's no generalized exception to regular constitutional scrutiny that's written into the Constitution for foreign policy. A lot of areas involving foreign policy have led to severe abuses of constitutional rights and things that have made us less safe. You can cite Korematsu and many other examples.
All citizens.
So what? I mean, really.
I mean, this is a fundamental divide. Ilya does not think the Constitution, or I think the Constitution doesn't apply to non-citizens. Ilya would take a very different position. We've had this debate now for some years. That's the basic divide. I'm okay with heightened scrutiny when involving U.S. persons, right? That's why Korematsu is an apposite. The reason why the plaintiffs didn't cite Korematsu in the brief, it's not relevant.
So some of the briefs actually did cite Korematsu,
did.
but I would note generally that even under current jurisprudence, there's no general exemption from non-citizens for constitutional rights. Non-citizens, for a wide range of contexts, are given constitutional rights. There's even in current jurisprudence cases forbidding discrimination against non-citizens for there being non-citizens on a wide
in the
range.
United States.
Yeah. So there is some discrimination based on being outside the United States, although even there, I've gone through some of the points about the precedents before, but the key point is that no such discrimination is written into the text of the Constitution, nor is it there in the original meaning, and I think we can forbid it without doing very much violence to existing precedent.
So, some other questions?
Okay, so Ilya, you cited as evidence that there have been a lack of attacks by refugees in the United States. But do do we not take into account attacks by foreign nationals and also attacks by refugees in places like Germany? And also, is a preventative approach not appropriate to uphold the executive order?
So these are two interesting questions. One is the European evidence relevant to the U.S.? I would say a couple of things about the European evidence. One is it's much less relevant than American evidence because Europeans' processes for assimilating immigrants are much different from those in the U.S. Among other things, many European countries, including Germany, have very closed labor markets, which make it very difficult for people to be involved in legitimate work and the like. That impedes assimilation. It also increases social pathologies of various kinds that then lead people to be more likely to be attracted to radical ideologies and the like. I would say even in Germany, however, terrorist attacks by immigrants and refugees from the particular countries covered by Trump's travel ban are still extremely rare, and the risks there are still much lower than the risk of being struck by lightning in a given year in Europe. So we're still talking about a very low risk even on European evidence, so I think the American evidence is much more relevant. You can say, well, why not take a preventative approach? I would say that if a preventative approach might be reasonable if you had evidence that you were actually preventing something. But we have decades of evidence suggesting that the risk that we're preventing, if any, is minimal, whereas on the other hand, we're actually increasing risks by barring people who might be useful to us, by aiding ISIS, and so forth. So that risk is that the risk that will cause harm is actually much greater than the risk that will create any kind of benefit. Now, as I mentioned before, all of this analysis of the risk might not be relevant if there were no evidence of illicit unconstitutional motivation here. But once there is such evidence, especially once there is as much of that evidence as there is here, then the burden of proof is on the government. And if they can't show a legitimate national security rationale, and frankly, they haven't even come remotely close to doing so, then they deserve to lose.
I'll waive it. Last question?
No, it was a question.
Historically, a number of the founders expressed skepticism that the federal government had any power over immigration. I believe Thomas Jefferson expressed some skepticism in that regard. I believe he was remembering that. And obviously, we've gotten pretty far away from that now. So I was wondering, how has the current doctrine regarding immigration developed, and what do you think those?
I'll let Ilya is an expert on this one. I'll let you have that.
Yeah. So there isn't the tradition of the dominant view at the time of the founding and for many years thereafter was that the federal government didn't even have a general power to exclude migrants from abroad, that power primarily resided in the states. As you mentioned, that was Jefferson's view. It was also James Madison's view and that of many of the other founders, not all, but probably a majority of them. And indeed, for the first 100 years or so of American history, there was virtually no federal legislation excluding immigrants except for the Alien and Sedition Act, the alien part of it, not the sedition part of it, and the constitutionality of that was much contested by both Jefferson and Madison and others, and when Jefferson became president, he allowed it to quickly expire, in part because he thought it was unconstitutional. He also didn't enforce it. In the late 19th century, the Supreme Court ultimately ruled in the so-called Chinese exclusion cases that there was a general federal power to exclude immigrants. Interestingly, they admitted that it couldn't be found in any specific enumerated power. They just said that this is an inherent power that all sovereigns must have, so it's got to be in there somewhere. Historians have found that this decision and other policy shifts during this period were heavily influenced by racism, xenophobia, and the like. The Supreme Court in the Chinese exclusion decision even refers to invading hordes of Chinese who are inimical to our culture and the like, and there's other references to that, like that in Supreme Court cases. In my view, Jefferson and Madison were correct, at least as a matter of original meaning, and there is no general federal power over immigration. But with respect to the travel ban case, I don't need to make any such broad sweeping claim. Even if there is a federal power over immigration, and even if it's broad in the sense that Congress has the general power to exclude people from abroad anytime they want, all I'm saying is that that power, like every other federal power, is limited by constitutional constraints in the Bill of Rights. So the court has said that there is a plenary power over immigration. They've also said that there's a plenary power over interstate commerce. Doesn't mean that we can forbid, say, Jews or evangelical Christians or Muslims from engaging in interstate commerce. Similarly, I think this also applies to the claim which is often made that, well, people have no constitutional right to immigrate. That may be true. They also don't have a constitutional right, for example, to Social Security benefits. It doesn't, the Supreme Court actually said that they don't. That doesn't mean that you can say Social Security benefits are available to Christians but not to Jews. Similarly, discrimination on a constitutionally prohibited category is forbidden, even if the benefit in which to which discrimination applies is also not in itself a constitutional right. So that is a big topic. What is the extent of federal power of immigration? We will cover in my con law class in a week or two. I know you're in my class and some of the other people here as well. But even if you think the current precedent on that is totally sound, Congress has power over immigration just like it has over interstate commerce. It still can be limited by the Bill of Rights.
One more question?
Going once.
Okay, well, now I think you can thank the panelists.
Thank you.